District judiciary. I am using the word district judiciary. Why I am using this word district judiciary? First we should know each and every individual is not affordable to approach the High Court and Supreme Court. That's why the large number of cases are pending in district judiciary. Though the law minister referred the pendency is 35 lakhs, but actually not that. The district judiciary pendency is only 13 to 14 lakhs, and in High Court the pendency is around 3 lakh, including the 2 benches. That is the reason I am referring the district judiciary. More number of people are approaching the district judiciary. That's why the district judiciary must be strong and strengthened with equipping with new laws. Maybe they have given different names, but almost the law, earlier law is same, but only some changes are made. In broad picture, all these 3 enactments is concerned, only one section is introduced in Evidence Act. Only one section, new section is added in Evidence Act. In CRPC, only new sections are only 10 sections. And other sections only defining the definitions. Section 2 mainly. But sections are made now more. Earlier it was 484, now 531 sections are there in BNSS. In BNS also, only not made major changes made in CRPC. But sections are reduced in BNS. Earlier 511 sections were there, now I think it is 358 sections are made in new section BNS. But we have to see what is the role of judiciary. The role of judiciary is quest for truth. Then we have to see what is quest for truth. ಕನ್ನಡದಲ್ಲಿ ಹೇಳಬೇಕು ಅಂತಂದರೆ ನ್ಯಾಯಾಂಗದ ಕೆಲಸ ಸತ್ಯಾನ್ವೇಷಣೆ ಅಂತ ನಾವು ಹೇಳ್ತೀವಿ. ಈ ಸತ್ಯಾನ್ವೇಷಣೆ ಏನಂತಂದು ನಾನು ಈಗಾಗಲೇ ಒಂದು ಎಕ್ಸಾಂಪಲ್ ಮೊದಲೇ ಕೊಟ್ಟೆ. ಗಾಂಧೀಜಿಯವರು ಹೇಳಿದ್ದು ಮಸ್ಟರ್ ದಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಆ್ಯಂಡ್ ಲಾ ಅಂತ. ಫ್ಯಾಕ್ಟ್ಸ್ ನಥಿಂಗ್ ಬಟ್ ಟ್ರುತ್ ಅಂತ ಹೇಳಿದೆ. ಯಾವಾಗ ನಾವು ಟ್ರುತ್ತನ್ನು ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇಡ್ತೀವಿ, ಬೋತ್ ವಿ ಆರ್ ಹ್ಯಾವಿಂಗ್ ದಿ ಸಿಸ್ಟಮ್ ಆಫ್ ಡಿಫೆನ್ಸ್ ಆಲ್ಸೋ ಟ್ರಯಲ್ ಮಾಡಬೇಕಾದ್ರೆ. ದಟ್ಸ್ ವೈ ಐ ಥಿಂಕ್ ದಿ ಲಾ ಮಿನಿಸ್ಟರ್ ಆಲ್ಸೋ ಪೋಸ್ ದಿ ಕ್ವಶನ್ ವೈ ಅಡ್ವೊಕೇಟ್ಸ್ ಆರ್ ಕೀಪಿಂಗ್ ಕ್ವೈಟ್. ದ ರೈಟ್ ಈಸ್ ಟೇಕನ್ ಅವೇ. ದಟ್ಸ್ ವಾಟ್ ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಅವರು ಹೇಳಿದರು. That we have to look into in this new enactment also. Quest for truth means conducting of a trial by giving an opportunity to the both sides. Old ಎವಿಡೆನ್ಸ್ ಆ್ಯಕ್ಟಲ್ಲೂ ನಿಮಗೆ ಗೊತ್ತಿದೆ, ಸೆಕ್ಷನ್ 165 ಜಡ್ಜಸ್ಗೆ ಇರ್ತಕ್ಕಂಥ ಪವರ್. ಯಾವಾಗ ಬೋತ್ ಸೈಡ್ಸ್ were not able to put forth the material before the court, that judge has given the powers to pose a question to the both the sides, even to the witnesses, to get an answer from the mouth of the witness to find out the truth and to give an appropriate decision. That is section old 165. That is why I said job of the court is to find out the truth. Now we have to see, bringing of these 3 enactments, what is the object in particularly this enactment BNSS. I don't have much time to deal with all these 3 subjects, but I dealt with this all the subjects in Abhivakta Parishat in Bangalore. But I made some short notes type also. I never makes any prepare notes also. Usually I give extempo speech, but I prepare a note also on this. Now we have to see what is the object in bringing this enactment, BNSS. This enactment is repealing Old Criminal Procedure Code 1973. And the object and reasons for bringing this enactment is for the fast and efficient justice system, which is an essential component of good governance. ನಿಮ್ಮ ಕೆಳಗಡೆ ಒಂದು ಇವತ್ತು ಓಪನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಒಂದು ವರ್ಡ್ ಇತ್ತು ಯೂಸ್ ಮಾಡಿದರು, ನೋಡಿದ್ರಾ? ಗುಡ್ ಗವರ್ನೆನ್ಸ್ ಅಂತ. ಸ್ಟೇಷನರಿ ಮಾರುವಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಗುಡ್ ಗವರ್ನೆನ್ಸ್ ಅಂತ ಒಂದು ಕೋಟ್ ಹಾಕ್ಕೊಂಡಿದ್ದೀರಿ. ಕೋಟ್ ಅದೇನೆ ಮೇನ್ ಥೀಮು. ವೈಲ್ ಅಮೆಂಡಿಂಗ್, ನಾಟ್ ಅಮೆಂಡಿಂಗ್, ಎನಾಕ್ಟಿಂಗ್ ನ್ಯೂ ಎನಾಕ್ಟ್ಮೆಂಟ್, ಟೇಕ್ ಅ ನೋಟ್ ಆಫ್ ಡಿಲೇ ಇನ್ ಡೆಲಿವರಿ ಆಫ್ ಜಸ್ಟಿಸ್ ಸಿಸ್ಟಮ್ ಡ್ಯೂ ಟು ಕಾಂಪ್ಲೆಕ್ಸ್ ಲೀಗಲ್ ಪ್ರೊಸೀಜರ್ಸ್. ಅರ್ಲಿಯರ್ ಪ್ರೊಸೀಜರಲ್ಲಿ ಭಾಳಷ್ಟು ಓಲ್ಡ್ ಎನಾಕ್ಟ್ಮೆಂಟ್ ಆದ್ದರಿಂದ, ದೋ ಇಟ್ ಈಸ್ ನಾಟ್ ಎ ಕನಾಲಿಯಲ್ ದಿ ಕೋಡ್, 1973 ಕೋಡ್ ಅದು. 1860 IPC, 1872 Evidence Act. But we made some changes subsequently after the independence in the year 1973. And hence this code cannot be called as colonial the code. And the main intention is to reduce the pendency and give speedy disposal. That is an enactment object also. Low conviction rates irtakantadna reduce ಮಾಡೋದು. Insufficient use of technology in legal system, which is hindering in dispensation of justice, to make this as effective system. For example, effective system of investigation system. Inadequate use of forensic are the biggest hurdles in speedy delivery system, which impacts poor man adversely. In order to address these issues and to make the procedural aspects in dispensation of justice with an intention to make the same as citizen-centric procedure, thought that it is need of the hour to streamline the procedure and adopt new procedure to subserve the purpose with that object, proposed to repeal the earlier enactment and brought new enactment which provides for the use of technology. Why I am using the word more technology? Because of globalization and computerization subsequent to the after independence. We have made lot of changes in globalization as well as computerization also. Now the digital era is now pressing for need of some new enactments also. Use of technology and forensic science in the investigation of crime alli, furnishing and lodging of information, serving of summons through electronic communications. All these are included in the new enactment. Even new enactment also introduced zero FIR and also e-FIR. What is meant by zero FIR? Zero FIR is nothing but registering the case. Wherever you can go there and lodge a complaint, police have to receive the complaint and register the same. Then they can forward it to the concerned jurisdictional police for the investigation. That is, e-FIR means is nothing but registering the FIR based on the information of crime. Digital ಮೂಲಕ ಏನು ಇನ್ಫಾರ್ಮೇಷನ್ ಕೊಡ್ತಾರೆ, ದಟ್ ಈಸ್ FIR is nothing but first information. Any information is given to register the e-FIR by receiving the digital mode of complaint. The central government also even given guidelines also. What is the mode of registration of zero FIR and also the e-FIR? Home Affairs, Ministry of Home Affairs also introduced the guidelines how to inquire into, how to register. That means steps are provided. 7 steps are provided in the home zero FIR. ಸಬ್ಜೆಕ್ಟ್ ಎಸ್ ಒ ಪಿನ ಮಾಡಿದ್ದಾರೆ ರಿಗಾರ್ಡಿಂಗ್ ಜೀರೋ FIR ಆ್ಯಂಡ್ FIR ಇಂಟ್ರೊಡಕ್ಷನ್ಸು ನ್ಯೂ ಎನಾಕ್ಟ್ಮೆಂಟಲ್ಲಿ. ಅದರಲ್ಲಿ ಸ್ಕೋಪು, ಆಮೇಲೆ ಆಬ್ಜೆಕ್ಟಿವ್ಸ್ ಏನು ಅಂತ, ಸ್ಟ್ರೀಮ್ ಲೈನ್ ದಿ ಪ್ರೋಸೆಸ್ ಆಫ್ FIR ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆ್ಯಂಡ್ ಮೇಕ್ ಇಟ್ ಅಕ್ಸೆಸಬಲ್ ಟು ಆಲ್ ಸಿಟಿಜನ್ಸ್ ಟು ಎನ್ಶ್ಯೂರ್ ಟೈಮ್ಲಿ ಆ್ಯಂಡ್ ಎಫಿಷಿಯಂಟ್ ಹ್ಯಾಂಡ್ಲಿಂಗ್ ಆಫ್ ಕಂಪ್ಲೇಂಟ್ಸ್, ಇಮಿಡಿಯೇಟ್ receiving of complaint, to maintain a transparent and accountable system for FIR management. Zero FIR registration, lodging a zero FIR under BNSS step 1. A complainant approaches any police station irrespective of territorial jurisdiction under section 173(1) nalli BNSS to complain. Step 2. On the receipt of any information regarding the commission of cognizance offense which has been committed outside of the territorial jurisdiction of that police station, the SHO or the officer on duty records the details of complaint in the zero FIR, irrespective of the jurisdiction, shall register the case as zero FIR or zero FIR under relevant sections of law. Then as per provisions of section 173, what they have to do. Then other steps are also, even in case offences are more than 3 years to 7 years punishment, then make the preliminary inquiry without prejudice to the provisions contained in section 175 on receipt of information relating the commission of any cognizable offence which is made punishable for 3 years or more but less than 7 years. The officer in charge of the police station may, with the prior permission from an officer not below the rank of deputy superintendent of police, considering the nature and gravity of the offence, proceed to conduct preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days. Time stipulation is also given. Next, third, second one, proceed with investigation when there exists a prima facie case. But investigation officer has to, while making the preliminary inquiry, has to comes to a conclusion that there is a prima facie material to proceed. Then steps 3, registration and copy to the complainant. Almost similar earlier. After fulfilling the requirements under section 173 BNSS, the officer registers the zero FIR. The FIR number is prefixed with 0. To indicate it is a zero FIR, a copy of the information as recorded under subsection 1 shall be given forthwith, free of cost, to the informant or the victim under section 173 subclass 2 BNSS. After the registration of zero FIR, if necessary, primary investigation may be done by the investigating officer of same police station. Example, medical examination of a rape victim also can consider it. Next, transfer, step 4. The officer forwards the zero FIR to the police station having jurisdiction over the place of the incident. Step 5. The concerned police station receives the zero FIR and registers it as a regular FIR in their records. They have to maintain. The SHO assigns the FIR to an investigating officer for further action. Then investigation, step 7. The investigating officer proceeds with the investigation as per standard procedure and BNS. Step 8. Regular updates on the investigation are provided to the complainant. Then what about EFIR registration, introduction, first one. Step 1. The complainant logs into the official police EFIR. Here very important. Complainant logs into the official police EFIR portal irutte, aa portal alli or police website, or may send the complaint information to the concerned police station through any electronic communication. That is one step. As per section 173(1) of the Bharatiya Nagarika Suraksha Sanhita, every information relating to the commission of a cognizable offence, irrespective of the area where the offence is committed, may be given orally or by electronic communication. Then step 2. The complainant fills in the required details or submits the following information in his complaint, including the personal information, details of the incident, and any supporting documents or evidence. The message so received electronically may be downloaded and kept in a computer in the police station. The electronic information relating to the commission of a cognizable offence may be entered in the e-complaint, e-FIR register as prescribed by the head of the department. Then verification and preliminary inquiry. After forwarding the complaint, steps 3. The submitted e-FIR is forwarded to the investigating officer for initial verification. As for 173 subclass 3 of BNSS, without prejudice to the provisions contained in section 175, on receipt of information relating to the commission of any cognizable offence, which is made punishable for 3 years or more, but less than 7 years, again same. The officer in charge of the police station may, with the prior permission from an officer of the not below the rank of deputy superintendent of police, considering the nature and gravity of the offence, proceed to conduct preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days, or proceed with investigation when there exists a prima facie case. That means 14 days he has to take a decision by conducting a preliminary inquiry. Thereafter, if we find the material, proceed for investigation. Then registration within 3 days. Now also time is stipulated. Step 4. If the information is sent through electronic communication, the same shall only be taken on record by police official, being signed within 3 days by the person giving it. There is a condition. It which means after signing the same FIR will be registered. As per section 173 of the Bharatiya Nagarika Suraksha Sanhita BNSS, every information relating to the commission of a cognizable offence, irrespective of the area where the offence is committed, may be given orally or by electronic communication, and if given to an officer in charge of a police station, orally it shall be reduced to writing by him or under his direction and be read over to the informant, and every such information, whether given in writing or reduced to writing, is aforesaid, shall be signed by the person giving it. Reduce ಮಾಡಿ ರೈಟಿಂಗಿಗೆ ಮಾಡಿಕೊಂಡು ಸಿಗ್ನೇಚರ್ ತೊಗೊಳ್ಬೇಕು. These are the steps are given even in e-FIR also. Steps 3, steps 4 preliminary inquiry within 3 days. Then if it is electronic communication, then also in the event that person against whom an offence under section 64, 65, 66, 67, 68, all sections are now introduced in new enactment, is alleged to have been committed or attempted, is temporarily or permanently mentally or physically disordered, the recording of such information shall be videographed. This is also made in the provision that videographed. The police officer shall get the statement of the person recorded by a judicial magistrate under clause A of subsection 6 of section 183 as soon as possible. However, if the nature and gravity of the information sent to police station through electronic communication requires immediate action, interference by police, matter may be registered on behalf of the complainant by the investigating officer himself when he receives the information through digital mode, after verifying the facts and circumstances of the information. Then next, step 5. A copy of the FIR is to be given to the complainant as per same earlier assignment. Step 6. The SHO of the concerned police station reviews the FIR and assigns it to an investigating officer. Next, step 7. The investigating officer conducts the investigation as per the standard procedure. Remedy for citizens for non-registration of e-FIR iddaga and zero FIR by police officer iddaga, what is the remedy? The remedy is provided under section 173 for BNS. Remedy under section 173. As per section 173 for BNS, any person aggrieved by a refusal on the part of the officer in charge of a police station to record the information referred to in subsection 1 may send the substance of such information in writing and by post to the superintendent of police concerned, who, if satisfied that such information discloses the commission of a cognizable offence, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him in the manner provided by the Sannihita, and such officer shall have all the powers of an officer in charge of the police station in relation to that offence, failing which such aggrieved person may make an application to the magistrate. Almost earlier ಏನಿತ್ತು ಅದೇನೆ, ಬಟ್ ಈ FIR ಕೂಡ ಸೇಮ್ ಇದು ಮಾಡಿದ್ದಾರೆ. ನೀವು earlier also when police refused to register the case, used to go to the magistrate also. Here also provision is made to the SP also. Then remedy under section 199 ಬೇರೆ. 199 BNS ಅಲ್ಲಿ public servant disobeying direction under law, whoever being a public servant knowingly disobeys any direction of the law which prohibits him from requiring the attendance at any place of any person for the purpose of investigation into an offence or any other matter, or knowingly disobeys to the prejudice of any person any other direction of the law regulating the manner in which he shall conduct such investigation, fails to record any information given to him under section 1 of section 174 of the Bharatiya Nagarika Suraksha Sanhita and other officers, shall be punished with rigorous imprisonment for a term which shall not be less than 6 months but which may extend to 2 years, and shall also be liable to fine. Even for refusal also made him to undergo a sentence. These are the steps are provided by the issuing SOP by the Home Affairs of the central government has issued this. This is all with regard to the setting of law of motion by registering 0 FIR and also the EFIR. Now we have to look into the what are the changes made in the enactment. New enactment, that is ಭಾರತೀಯ ನಾಗರಿಕ ಸುರಕ್ಷಾ ಸಂಹಿತ. ಡೆಫಿನೇಷನ್ಗೆ ಹೋಗಬೇಕು. ನೀವು ಡೆಫಿನೇಷನಲ್ಲಿ ಮೇಯ್ನ್ ಏನಂದರೆ ನಾವು 5 ಡೆಫಿನೇಷನ್ ಅಮೆಂಡ್ ಮಾಡಿದ್ದಾರೆ. ಒಂದು ಆಡಿಯೋ ವಿಡಿಯೋ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಮೀನ್ಸ್, ನಾನೀಗ ಆಲ್ರೆಡಿ ಹೇಳಿದೆ, ಅದನ್ನು ಸೆಕ್ಷನ್ 2(1)A ಅಮೆಂಡ್ ಮಾಡಿದ್ದಾರೆ. 2 2(1)B ಬೇಲ್ ಅಂದರೆ ರಿಲೀಸಿಂಗ್ ಫ್ರಮ್ ಲಾಫುಲ್ ಕಸ್ಟಡಿ, ದಟ್ ಈಸ್ ದಿ ಡೆಫಿನೇಷನ್ ಇನ್ ಬೇಲ್ ಬಾಂಡ್. ಹಿಯರ್ ನೋಡಿ, ಬೇಲ್ ಬಾಂಡ್ ಅಂದರೆ ಸೆಕ್ಷನ್ 1D, ಬೇಲ್ ಬಾಂಡ್ ಇನ್ಕ್ಲೂಡ್ಸ್ ದಿ ಸೂರಿಟಿ ಇರ್ತದೆ ಬೇಲ್ ಬಾಂಡ್ಗೆ, ದಟ್ ಈಸ್ ದಿ ಡೆಫಿನೇಷನ್ ಗಿವನ್ ಇನ್ ದಿ ನ್ಯೂ ಸೆಕ್ಷನ್ 2(1)D. ನೆಕ್ಸ್ಟ್ 2(1)E ಬಾಂಡ್ ಅಂದರೆ ಓನ್ಲಿ ಪರ್ಸನಲ್ ಬಾಂಡ್ ತಗೊಂಡು ಬಿಟ್ಟು ಕಳಿಸೋದು ವಿತೌಟ್ ಸೂರಿಟಿ. ದಿಸ್ ಆರ್ ದಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮೇಡ್ ಟು ದಿ ಡೆಫಿನೇಷನ್. ದೆನ್ ಸೆಕ್ಷನ್ 2(1)I ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಕಮ್ಯುನಿಕೇಷನ್. ನಾನು ಈಗಾಗಲೇ ಹೇಳಿದೆ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಕಮ್ಯುನಿಕೇಷನ್ ಯಾವ ರೀತಿ ಕಳಿಸ್ಕೊಡ್ಬೇಕು FIRನ ಅಂಥೇಳಿ ಈಗ ಆಲ್ರೆಡಿ ರೆಫರ್ ಮಾಡಿದ್ದೀನಿ. ಡಿಜಿಟಲ್ ಮೋಡಲ್ಲಿ ಕಳಿಸ್ಕೊಳ್ತಕ್ಕಂಥದ್ದು. ನಾವು there are 10 sections are introduced. First one is section 37, ಅಂದರೆ ಡೆಸಿಗ್ನೇಟೆಡ್ ಪೊಲೀಸ್ ಆಫೀಸರ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಹೊಸ ನ್ಯೂ ಸೆಕ್ಷನ್ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರ್ತಕ್ಕಂಥದ್ದು. ಡೆಸಿಗ್ನೇಟೆಡ್ ಪೊಲೀಸ್ ಆಫೀಸರು ಅಂದರೆ ಡೆಸಿಗ್ನೇಟೆಡ್ ಪೊಲೀಸ್ ಆಫೀಸರ್ಗೆ ಹೊಸ ಸೆಕ್ಷನ್ನಲ್ಲಿ ಡೆಸಿಗ್ನೇಟೆಡ್ ಪೊಲೀಸ್ ಆಫೀಸರ್, ದ ಸ್ಟೇಟ್ ಗೌರ್ಮೆಂಟ್ ಶೆಲ್ establish a police control room in every district and at state level. Designate a police officer in every district and in every police station not below the rank of assistant sub-inspector of police, who shall be responsible for maintaining the information about the names and addresses of the persons arrested, nature of the offence with which charged, which shall be prominently displayed in any manner including in digital mode in every police station and at the district headquarters. The word is used, digital mode, because that's the reason I said the amendment is made mainly concentrating on in view of the digital world. This is the section 37 is made an was a new section is introduced in the same. Now then section 86 is also a new section is introduced. Identification and attachment of property of proclaimed persons. ಮೊದಲು ಅರ್ಲಿಯಲ್ಲೆಲ್ಲ ಸೆಕ್ಷನ್ 82, 83, 84 ಕಂಪ್ಲೇಂಟ್ಸ್ ಇತ್ತು. ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡದಿಲ್ದಾಗ ಏನು ಮಾಡಬೇಕು ಅಂತ. ಈಗ ಹೊಸ ಇದ್ರ ಪ್ರಕಾರ ಏನು ಅಂತ, ದಿ ಕೋರ್ಟ್ ಮೇ on the written request from a police officer not below the rank of the superintendent of police or commissioner of police, initiate the process of requesting assistance from a court or an authority in the contracting state for identification, attachment and forfeiture of property belonging to a proclaimed person in accordance with the procedure provided in chapter 8. Here they mentioned the rank of officers, police superintendent or commissioner of police. He has to make a request to the court for seeking an order for attachment, identification and forfeiture of the property. This is the new section is introduced in BNSS. Then other section is 111. 105. Ah, 105. 105 new section is introduced, recording of search and seizure through audio, video, electronic means. That is also mainly focus is made on the new era of digital evidence, collecting of material. Recording of search and seizure through audio, video, electronic means. The process of conducting search of a place or taking possession of any property, article or thing under this chapter or under section 185. Earlier section 102 nalli police officer used to seize, old section nalli, including preparation of the list of all things seized in the course of such search and seizure and signing of such list by witnesses shall be recorded through any audio, video, electronic means, preferably mobile phone. The word is used, preferably mobile phone. And the police officer shall without delay forward such recording to the district magistrate, subdivisional magistrate or judicial magistrate of the first class. Not only recording through the electronic mode, and also forward the same without conducting any delay. That is one of the new section is introduced in view of the new enactment. Now section 107, attachment, forfeiture or restoration of property. Attachment, forfeiture or restoration of property. Here the provision is made where a police officer making an investigation has reason to believe that any property is derived or obtained directly or indirectly as a result of criminal activity. The word is used, criminal activity, or from the commission of any offense, he may, with the approval of the superintendent of police or commissioner of police, make an application to the court or the magistrate exercising jurisdiction to take cognizance of the offense or commit for trial or try the case for the attachment of such property. This is only with regard to the attachment, forfeiture or restoration of property. If the court or the magistrate has reason to believe, whether before or after taking evidence, that all or any of such properties are proceeds of crime, the word is used, proceeds of crime, the court or the magistrate may issue a notice upon such person, calling upon him to show cause within a period of 14 days as to why an order of attachment shall not be made. Then subclass 3, where the notice issued to any person under subsection 2 specifies any property as being held by any other person on behalf of such person, a copy of the notice shall also be served upon such other person. Then the court or the magistrate may, after considering the explanation, if any, to the show cause notice issued under subsection 2 and the material fact available before such court or magistrate, and after giving a reasonable opportunity of being heard to such person or persons, may pass an order of attachment in respect of those properties which are found to be the proceeds of crime, provided that if such person does not appear before the court or the magistrate or represent his case before the court or magistrate within a period of 14 days specified in the show cause notice, the court or the magistrate may proceed to pass the ex parte order. Here also very clear that when the application is made to the court, the principle of ade altem partem also applies. An opportunity has to be given to the party in whose the criminal proceeds is in his custody. After hearing, only giving an opportunity only to pass an order. That is principles of complying of natural justice. That's why this procedure is made in the section. Subclass 5, notwithstanding anything contained in subsection 2, if the court or the magistrate is of the opinion that issuance of notice under the said subsection would defeat the object of attachment, a seizure, the court or judicial magistrate may be pass an interim order, pass ex parte direct attachment or seizure of such property, and such order shall remain in force till an order under subsection 6 is passed. Here also discretion is given to the magistrate. Even he can pass an ex parte order also without giving any notice also. Then subclass 6. If the court, the magistrate finds that attached or seized property to be the proceeds of crime, the court or the judicial magistrate shall by an order direct the district magistrate to rateably distribute such proceeds of crime to the persons who are affected by such crime. The power is also given to rateable distribution from whom it was stolen. That is also included. Next section, subsection 7. On receipt of an order passed under subsection 6, the district magistrate shall, within a period of 60 days, distribute the proceeds of crime either by himself or authorize any officer subordinate to him to effect such a distribution. Here also, time stipulation is made within 60 days. He has to distribute the same. Then subclass 8. If there are no claimants to receive such proceeds, or no claimant is ascertainable, or there is any surplus after satisfying the claimant, such proceeds of crime shall stand forfeited to the government. If no such claim is made, avaga forfeit madabodu. That is only if no claim is made, if it is excess available, that is also powers is given to the court as well as district magistrate. Then this is section 107. This is regarding attachment, seizure and forfeiture of the property. Then section 172. Here it is very important. New section is introduced. Persons bound to conform to lawful directions of police. That is his duty to answer some of the questions. 172. Persons bound to conform to lawful directions of police. Here the word is used. All persons shall be bound to conform to the lawful directions of a police officer given in fulfillment of any of his duty under this chapter. Subclass 2. A police officer may detain, the word is used, detain or remove any person resisting, refusing, ignoring or disregarding to conform to any direction given by him under subsection 1. These are all the powers are given, and may either take such person before a magistrate or in petty cases release him as soon as possible within a period of 24 hours. Time stipulation is also given in case of petty offences within 24 hours, or even detain him in his custody. That is, all persons are bound to give answers to the police custody. This is section 172. Then section 336. The evidence of public servants, experts, police officers in certain cases. Because this is also made with an intention to free disposal. That is the concept of free disposal. That's why what section 336 says, evidence of public servants, experts, police officers in certain cases, where any document or report prepared by a public servant, scientific expert, medical officer is purported to be used as evidence in any inquiry, trial or other proceeding under this Sannihita, and one such public servant, expert or officer is either transferred, retired or died, or such public servant, expert or officer cannot be found or is incapable of giving deposition or securing presence of such public servant, expert or officer is likely to cause delay in holding the inquiry, trial or other proceeding. The word is used, the court shall secure presence of successor officer of such public servant, expert or officer who is holding that post at the time of such deposition to give deposition on such document or report. Then, provided that no public servant, scientific expert or medical officer shall be called to appear before the court unless the report of such public servant, scientific expert or medical officer is disputed by any of the parties of the trial or the proceeding. Provided further that the deposition of such successor, public servant, expert or officer may be allowed through audio, video, electronic means. Even provided for securing them audio, video also. If other side not disputes that document, no need to summon the expert, may be a scientific or medical. Once you give a consent for marking of document, then again you cannot question the same. That is what the provision. If not found, then successor who is having the knowledge about the document, he can be summoned. These are the procedures are made in section 336. Only question arises if only dispute is made in respect of the particular document of scientific expert or medical expert or any of the document. Then 356, this is very important. Now the Law Minister also raised the question with regard to this aspect is concerned. 356, inquiry, trial or judgment in absentia of proclaimed offender. Earlier what we used to do under section 299, we used to send, if accused is not secured, used to split case, register the split up case. Then to send the file to the LPC. After securing the accused only, you used to make the trial. Only in the presence of accused, trial will be conducted. In the absence of the accused, there cannot be any trial. The basic concept in criminal jurisprudence, you all know that an innocent person cannot be convicted even if 100 accused persons are not comes within the clutches of law. An innocent person should not be punished. But here is an issue. Madras High Court also issued notice to the central government in view of the enactment when this question was raised before the Madras High Court. Now the issue is with regard to, but this section is elaborate, but we have to read the entire section. Then only we come to know what is the consequences in view of this news, introducing of new section. Here the word is used, inquiry, trial or judgment in absentia of proclaimed offender. The proviso says to proceed with the case, record the evidence in the absence of accused also. Proceed, not to send the record to the LPC as earlier it was under section 299. Now I am reading section. Notwithstanding anything contained in this Sanhita or in any other law for the time being in force, when a person declared as a proclaimed offender, whether or not charged jointly, has absconded to evade trial, and there is no immediate prospect of arresting him, it shall be deemed to operate as a waiver, the right of waiver of the right of such person to be present and tried in person, and the court shall, after recording reasons in writing, court has to record the reasons, in the interest of justice, proceed with the trial in the like manner and with like effect as if he was present under this Sanhita and pronounce the judgment. The proviso is even proceed to record evidence and also pronounce the judgment. Then provided that court shall not commence the trial unless period of 90 days has elapsed from the date of framing of the charge, and also laid a condition not to proceed before 90 days. The court shall ensure that following procedure has been complied with before proceeding under subsection 1, namely, then they have to follow the procedure. Then what is the procedure? Issuance of 2 consecutive warrants of arrest within the interval of at least 30 days. Time is also stipulated. Publish in a national or local daily newspaper circulating in the place of his last known address of residence, requiring the proclaimed offender to appear before the court for trial, and informing him that in case he fails to appear within 30 days from the date of such publication, the trial shall commence in his absence. Paper publication kodಬೇಕು. Inform his relative or friend, if any, about the commencement of the trial. Affix information about the commencement of the trial on some conspicuous part of the house or homestead in which such person ordinarily resides, and display in the police station of the district of his last known address of residence. Then 3. Where the proclaimed offender is not represented by any advocate, he shall be provided with an advocate for his defense at the expenses of the state. ಅಡ್ವೊಕೇಟ್ನು ನಾಮಿನೇಟ್ ಮಾಡಿ ಅವನಿಗೇನು ಡಿಫೆನ್ಸ್ ಕೊಡೋಕ್ಕೆ ಮಾಡಬೇಕು. Then where the court competent to try the case or commit for trial has examined any witnesses for prosecution and recorded their depositions, such depositions shall be given in evidence against such proclaimed offender on the inquiry into or in trial for the offence which he is charged, provided that if the proclaimed offender is arrested and produced or appears before the court during such trial, the court may, in the interest of justice, allow him to examine any evidence which may have been taken in his absence. That procedure is also laid down. Where a trial is related to a person under this section, the deposition and examination of the witness may, as far as practicable, be recorded by audio, video, electronic means, preferably mobile phone, and such recording shall be kept in such manner as the court may direct. Then, in prosecution for offences under this Sannihita, voluntary absence of accused after the trial has commenced under subsection 1 shall not prevent continuing the trial, including the pronouncement of the judgment, even if he is arrested and produced or appears at the conclusion of such trial. No appeal shall lie. The word is used here, the proviso 7. No appeal shall lie against the judgment under this section unless the proclaimed offender presents himself before the court of appeal. His personal presence is must while filing the appeal also, provided that no appeal against conviction shall lie after the expiry of 3 years from the date of the judgment. The state may, by notification, extend the provisions of this section to any absconder mentioned in subsection 1 of section 84. These are the procedures are laid down. Earlier also you all know, even challenged before the Supreme Court before bringing enactment of this all enactment. Now then Supreme Court said that now it is not the time to consider this. Now already started initiating of proceedings in different high courts also. I don't know whether matter is filed before the Supreme Court or not. That's why I said earlier also, the criminal jurisprudence is very clear. A person cannot be punished without giving any opportunity. But here there is a provision is also made providing an advocate to defend the accused. But who has to give information to the advocate? Appointed him to defend. These are all the issues to be considered now, because this is the very impact on the criminal jurisprudence now. Section 356. This I think the court may take this also note while considering the challenging of constitutional validity of the section 356. You have to more concentrate on this section also regarding conditions imposed even while proceeding to conduct a trial in absentia of an accused who is a proclaimed offender. Now moving to section 398. This is witness protection scheme. You all know some of the witnesses are also facing problem in causing of threat to the witness. Now provision is also made, witness protection scheme. Now a new section is introduced. Every state government shall prepare and notify a witness protection scheme for the state with a view to ensure protection of the witnesses. That is, a direction is given to the every state government shall prepare and notify a witness protection scheme ಮಾಡಬೇಕು ಅಂತ ಒಂದು ಹೊಸ ಸೆಕ್ಷನ್ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ವಿಟ್ನೆಸ್ನ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡಲಿಕ್ಕೆ ಪ್ರಾವಿಷನ್ನ ಮಾಡಿದ್ದಾರೆ. ದೆನ್ ಅನದರ್ ಸೆಕ್ಷನ್ 472 ಮರ್ಸಿ ಪಿಟಿಷನ್ ಇನ್ ಕೇಸ್ ಆಫ್ ಡೆತ್ ಕ್ಯಾನ್ಸಸ್ ಇದ್ದಾಗ ಮರ್ಸಿ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಲಿಕ್ಕೆ ಪ್ರಾವಿಷನ್. Then we have to see section 530, trial and proceedings to be held in electronic mode. Section is also introduced. ಟ್ರಯಲ್ನ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಮೋಡ್ನಲ್ಲಿ ಮಾಡಬೇಕು ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಮರ್ಸಿ ಪಿಟಿಷನ್ ಅದು ಎಲಾಬ್ರೇಟ್ ಆಗಿದೆ, ನೀವು ನೋಡ್ಕೊಳ್ಳಿ. ಅದಿನೇ ಕೇಸ್ ಆಫ್ ಡೆತ್ ಸೆಂಟೆನ್ಸಸ್ ಕೇಸಸ್ ಇದ್ದಾಗ ಐ ಡೋಂಟ್ ವಾಂಟ್ ಟು ರೀಡ್ ದಿ ಸೇಮ್. ಬಟ್ ಸೆಕ್ಷನ್ 530 trial and proceedings to be held in electronic mode. All trials, the word is used, all trials, inquiries and proceedings under this code, including issuance, service and execution of summons and warrant, all are in the mode of electronic mode. Examination of complainant and witnesses, recording of evidence in inquiries and trials, and all appellant proceedings and such other proceedings may be held in electronic mode by use of electronic communication or use of audio video electronic means. Now section 530 is also introduced with regard to the recording of the trial, inquiries and all, even to the appellate court proceedings also through electronic mode. The important section 531, this is a important section, you have to read what it says. Here there is a repealing provision of old act and also there is a saving clause. This saving clause is very important, you have to read this. Though earlier enactment is repealed, savings clause is also made. Now some of the judges are also used to make call to me and to clarify what we have to do. ಅದಕ್ಕೆ ಈ ಪ್ರೊಸೀಜರ್ನ ಓದಬೇಕು. ಮೇನ್ ಅಡ್ವೊಕೇಟ್ಸ್ಗಳು ಕೂಡ ಅಷ್ಟೇ. ವಾಟ್ ಇಟ್ ಸೇಸ್, 17/2024ಗಿಂತ ಹಿಂದೆ ಯಾವುದೇ ಕ್ರೈಮ್ ಆಗಿರಲಿ, ಯಾವುದೇ ಅಫೆನ್ಸ್ ಆಗಿರಲಿ, ಏನೇ ಆಗಿರಲಿ, ಅದಕ್ಕೆ ನೀವು ಓಲ್ಡ್ ಸೆಕ್ಷನ್ CRPCಗೆ ಹೋಗಬೇಕು. ಹೊಸ ಅಫೆನ್ಸಸ್ಗಳು ಏನಾಗ್ತದೋ ಸೆಕ್ಷನ್ 1724ಇಂದ ಆವಾಗ ನೀವು BNSSಗೆ ಹೋಗಬೇಕು. ದಟ್ ಈಸ್ ಸೇವಿಂಗ್ ಕ್ಲಾಸ್. ಐ ವಾಂಟ್ ಟು ರೀಡ್ ದಟ್. ದ ಕೋಡ್ ಆಫ್ ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ 1970 ಹಿಯರ್ ಬೈ ರಿಪೀಲ್ಡ್. ದಟ್ ಈಸ್ ಸಬ್ ಕ್ಲಾಸ್ 1 is repealed. Sub class 2, this is very important. Notwithstanding such repeal, if immediately before the date on which this Sannihita comes into force, there is any appeal, application, trial, inquiry or investigation pending, then such appeal, application, trial, inquiry or investigation shall be disposed of, continued, held or made, as the case may be, in accordance with the provisions of the Code of Criminal Procedure Code. That's why you have to carefully read this provision. Saving clause is there. As in force immediately before such commencement, hereinafter referred to as the said code, as if this Sannihita had not come into force. That is the saving clause. Then 2. All notifications published proclamation issued, powers conferred, forms provided, by rules local jurisdiction defined, sentences passed, and orders, rules, and appointments not being appointments as special magistrate made under the said code, and which are in force immediately before the commencement of this Sannihita, shall be deemed respectively to have been published, issued, conferred, specified, defined, passed, made under the corresponding provisions of this Sannihita. Then you have to read the proviso 2. Then any sanction accorded or consent given under the said code, in pursuance of which no proceeding was commenced under the code, shall be deemed to have been accorded or given under the corresponding provisions of this Sannihita, and proceeding may be commenced under this Sannihita in pursuance of such sanction of consent. Then 3. Where the period specified for an application or other proceeding under the said code had expired, or before the commencement of this Sannihita, nothing in this Sannihita shall be construed as enabling any such application to be made or proceeding to be commenced under this Sannihita, by reason only of the fact that a longer period therefore is specified by the Sannihita, or provisions are made in this Sannihita for the extension of time. With regard to this aspect is concerned, even Delhi High Court and also even Goa High Court also delivered some judgments. But I would like to rely upon one judgment of recent judgment of Rajasthan High Court sitting at Jodhpur. Elaborately discuss section 531. You can note down this judgment also. You can take the judgment 9/7/2024. Judgment dated 9/7/24. SB Criminal Miscellaneous Petition number 4285 of 24. Krishan Joshi versus State of Rajasthan. Here is a case. FIR was registered on 2/2/24 prior to coming into force of the Bharatiya Nagarika Suraksha with effect from 1/7/24. In this judgment discussed with regard to section 531(2)(a, in the premise, in view of the saving clause contained under section 531(2)(a of the BNSS, the petition ought to have been filed under the old corresponding section 482 of Criminal Procedure Code 1973 and not under section 528 of the new code. Though it was the offence in the month of February 2024, but when the petition was filed under section 482 under the new enactment, this issue was raised. And taken note of section 531 subclass 2 subclass 2(3), discussion was made prior to coming into force. The reasons for the same are not for to seek. What has been seen simply is the date of registration of the FIR and the law as applicable as on the date of such registration. Trite it may sound, but settled position is that the moment an FIR is registered under section 154 of CRPC, criminal investigation administrative machinery is set in motion under chapter 12 thereof. Thus, if an FIR is registered prior to 1/7/2023 under the CRPC, it would amount to a pending inquiry investigation within the meaning of section 531(2)(a of the BNSS. The entire subsequent investigation procedure and even the trial proceedings qua such an FIR shall then be governed by the CRPC and not by BNSS. ನಮ್ಮ ಜಡ್ಜಸ್ಗಳಿಗೂ ಸ್ವಲ್ಪ ಕನ್ಫ್ಯೂಷನ್ಸ್ ಇದೆ, ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಸೆಕ್ಷನ್ 531 ಸಬ್ ಕ್ಲಾಸ್ 2ನಲ್ಲಿ Let us analyze it deeper by dwelling further on it. Legislative processes often involve simultaneous twin actions, that is, not only the creation of new law, but also the repeal of existing one at the same time. Section 531 of the new legislative code, for short referred to as BNSS, envisages the repeal of the Code of Criminal Procedure 1973. And it also incorporates crucial savings provision which is so essential to cater to the transitional period between the old code and the new code. No doubt Section 531 of BNSS effectively removes the old code from the statute books. However, at the same time it is repeal subject to the savings cause and not a repeal in toto. A certain transitional period has been provided, and rightly so, for a forthwith repeal in totality shall lead to legal uncertainties, particularly concerning ongoing legal proceedings that commence under the old law. To mitigate such uncertainties, saving provision has been introduced. Saving clause ensures that the repeal of an old law does not adversely affect any legal proceedings or rights that were established under the old code. The saving provision facilitates a smooth transition from the old legal framework to the new one. It provides a buffer period during which the judicial and legal systems can adjust to the changes introduced by the new Sanhita. The saving clause in Section 531 subclause 2 is critical for ensuring legal continuity and stability. It stipulates that notwithstanding the appeal, any appeal, application, trial, inquiry, which I read, this shall essentially mean that all going proceedings which have already been kicked under the old code will not be disturbed by the new code, that is BNSS. This is vital for maintaining the integrity of this judicial process and ensuring that justice is neither delayed nor denied due to procedural changes should an affected party feel so. Rights of the accused in an FIR and are under the trials and are convicts under appeal, and the legal expectations formed under the old law have been and are required to be protected. Applicability of the old code on pending matters prevents any retrospective adverse effects that might arise from the sudden application of new provisions to ongoing cases. Furthermore, wide saving clause, the litigants already involved in legal proceedings initiated under the old code have been thus assured that their cases will be resolved under the legal framework they were initially engaged with. Saving clause thus ensures that the repeal of old code does not create a legal vacuum, leaving ongoing proceedings in limbo. And to avoid such scenario, the old legal process ought to continue seamlessly. Speaking of judiciary, wide the savings clause which envisages dual approach, that is ongoing cases to be disposed of under the old law and the ones registered after 1723 under the new code. Even the courts can manage their workload more efficiently. Judges and lawyers are familiar with the old code, can continue to their work without needing to adapt immediately to the new provisions, Section 531 of the new Sanhita, while repealing of the Code of Criminal Procedure Code 1973. Simultaneously, the safeguards ongoing legal proceedings through its saving clause. No doubt procedure laws can be applied retrospectively, subject of course to the judicial review, but in review of Section 531 subclass 2A of the BNSS, herein it is amply clear that all pending matters prior to coming into forces of BNSS 2023, as specifically mentioned Section 531 subclass 2A of BNSS, shall continue to be governed by the old code, that is CRPC 1973. Therefore, the petition in hand also has to be treated under Section 482 of CRPC. It so transfers that learned counsel for the petitioner had, though rightly filed the instant petition initially under 482 CRPC, but on an objection raised by the registry of this court, it was converted into one under Section 528 of BNSS. In view of the discussion in the proceeding part here in above, the objection raised by the registry is overruled. The Present petition is resultantly treated as one under section 482 of CRPC, adverting now the merits of the case in hand, dissatisfied with the progress and matter of the investigation. The petitioner seeks issuance of directions to the officials correspondents to conduct a fair inquiry investigation in so and so. That is with regard to the factual case of that particular case. Now interpretation was given by the Rajasthan High Court also with regard to section 531 subclass 2 also. Old judge name is Arun Monga. Made it clear that saving clause, there is a saving clause, old all proceedings to be continued under the old act only. That's why now clarification is also there by the Rajasthan High Court in view of the saving clause of section 531 subclass 2A. Having considered this, the new enactment, I have already made it clear that 10 sections are introduced, new sections are introduced, and new procedures are also introduced in some of the cases, and provision is also made, and some of the provisions are also questioned before the different courts also. Madras High Court also given the notice with regard to particularly the section which takes away the right of defending the accused. Now we have to wait for the result. Now we have to consider the offences which are committed subsequent to the 1/7/2024. We have to adopt the BNSS. And in view of the saving clause under the section 531, you can make an application for all procedures under the criminal procedure code. Now I hope that I clarified with regard to the doubts which have been in the mind of the advocates also, and also the new sections which have been introduced, mainly concentrated on the regarding the globalization and digitalization. Now we are in the digital era of WhatsApp, email, and all communications. That is the reason this new enactment is brought into force. Changes are made only in CRPC more, even compared to BNS and also the BSA, ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ. ಅದರಲ್ಲಿ ಓನ್ಲಿ ಸೆಕ್ಷನ್ ಒಂದಿದೆ ಅಷ್ಟೇ, ಸೆಕ್ಷನ್ 61 ಇರಬೇಕು. ಡಿಜಿಟಲ್ ಎವಿಡೆನ್ಸ್ಗೆ ಎವಿಡೆನ್ಸ್ ಆ್ಯಕ್ಟಲ್ಲಿ ಅದೊಂದು ಚೇಂಜಸ್ ಮಾಡಿದ್ದಾರೆ. ದಟ್ ಈಸ್ ಮೇನ್. ನಾವು ದಿ challenges are also before the court as well as advocates also to take note of it, and also equip with new sections. That's what. New sections, almost all sections are reintroduced. Some changes are made with regard to the factual aspects and all, but only new sections are added, 10 sections and 5 definitions in CRPC. Anything? Yes.
For the sake of my submission, ಒಬ್ಬ KSRTC ಡ್ರೈವರ ಒಂದು ಶೀಪ್ ಕುರಿಗೆ ಎನಿಮಲ್ಗೆ ಹಾಸಿ ಕೊಂದುಬಿಡ್ತಾನೆ. ವೆದರ್ ಇಟ್ ಈಸ್ ಟ್ರೈಬಲ್ ಬಿಫೋರ್ ದಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಆರ್ ನಾಟ್.
ಈಗ ಸೆಕ್ಷನ್ 279 ತೆಗೆದು 306 ಒಂದು ಇಂಟ್ರೊಡ್ಯೂಸ್ ಅಲ್ಲ 106 ಒಂದು ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಹೊಸ ಎನಾಕ್ಟ್ಮೆಂಟಲ್ಲಿ. 304A ಒಂದು ಪ್ಯಾರಲಲ್ ಆಗಿ ಒಂದು ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಅದು ದಟ್ ಈಸ್ ಕೆಪ್ಟ್ ಇನ್ ಅಬೇಯನ್ಸ್. ಅದಿನ್ನು ಕೆಪ್ಟ್ ಇನ್ ಅಬೇಯನ್ಸ್, ಇನ್ನೂ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿಲ್ಲ. ಬಟ್ ನೀವು ಹೇಳ್ತಾ ಇರೋದು ಅಂದರೆ ಕುರಿ ಅವಾಯ್ಡ್ ಮಾಡೋಕ್ಕೆ ಹೋಗಿ ಆಕ್ಸಿಡೆಂಟ್ ಆಯಿತು ಅಂತ.
ಇಲ್ಲ ಸರ್, ಡೈರೆಕ್ಟ್ಲಿ ಕುರಿಗೇನೋ ಡ್ಯಾಶ್ ಮಾಡಿದಾಗ ಕುರಿ ಸತ್ತೋಯ್ತು.
ಆಯಿತು.
ಇಟ್ ಇಸ್ ನಾಟ್ ದಿ ಹ್ಯೂಮನ್ ಬೀಯಿಂಗ್. ಅದು ಕುರಿ ಸತ್ಕೂಲಿ ಅವರು 279 ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರು. ನಮ್ಮ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಬದಾಮಿ ಒಳಗೆ 20 ವರ್ಷದ ಸುದ್ದಿ 279 ಹಾಕಿದ್ರು. ದಟ್ ಸೌಂಡ್ ಜುಡಿಷಿಯಲ್ ಮೈಂಡ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ನಾನು ಸಬ್ಮಿಟ್ ಮಾಡಿದೆ. ಸರ್ ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಮೇಂಟೈನ್ ಆಗೋದಿಲ್ಲ.
ಪೆಂಡಿಂಗ್ ಕೇಸ್ ಬಗ್ಗೆ ನೀವೇನು ಕೇಳಬಾರ್ದು.
ಪ್ಲೀಸ್.
ಯಾಕೆ ಅಂತಂದರೆ ನಾಳೆ ಹೋಗಿ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ ಹಿಂಗೆ ಹೇಳಿದ್ರು, ನೀವೇನು ಹಿಂಗೆ ಮಾಡ್ತಾ ಇದ್ದೀರಿ. ಅಪರ್ಚುನಿಟಿ ಕೊಡೋದಿಲ್ಲ ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡಲ್ಲಿ. ಓನ್ಲಿ ಹಿ ಕ್ಯಾನ್ ಚಾಲೆಂಜ್ ದಿ ಕಾಗ್ನಿಜೆನ್ಸ್ ತಗೊಂಡಿನ ಬೇಕಾದ್ರೆ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೋದು. ಬಿಫೋರ್ ಟೇಕಿಂಗ್ ಕಾಗ್ನಿಜೆನ್ಸ್ ಇಲ್ಲ. ಮೋಸ್ಟ್ಲಿ ಸಮ್ ಎರರ್ ಮೇ ಬಿ ಕ್ರೆಪ್ಟ್ ಇನ್. ಓಲ್ಡ್ CRPC ನಾವು ನೋಡಬೇಕಾಗ್ತದೆ. ಆಗ ಓಲ್ಡ್ CRPCನಲ್ಲಿ ಏನಿದೆ ಅಂತ ಅದಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಈಗ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ಇದು ಅಮೆಂಡ್ ಆಗಿಲ್ಲ. ಸೇರಿಸ್ಬೇಕಾದ್ರೆ ಇದನ್ನು ಸೇರಿಸಿಲ್ಲ, ಚೇಂಜಸ್ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಬಿಫೋರ್ ಟೇಕಿಂಗ್ ಕಾಗ್ನಿಜೆನ್ಸ್ ಕ್ವಶನ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಏನ್ ಅಕ್ಯೂಸ್ಡ್ ಇಲ್ವೇ ಇಲ್ಲ.
ಅದೇ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಬೇಕಾಗಿ
ಅದೇ ಹೈಯರ್ ಕೋರ್ಟಿಗೆ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಬೇಕಾಗ್ತದೆ ಈ ಸೆಕ್ಷನ್. ಮೋಸ್ಟ್ಲಿ ಈ ಸೆಕ್ಷನ್ ಈಗ ಸೇರಿಸುವಾಗ ಪ್ರಾಬಬಲಿ ದಿಸ್ ಈಸ್ ಅಫೆನ್ಸ್ ಅಗೇನೆಸ್ಟ್ ಗೌರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ಸ್ ಇರ್ಬೋದೇನೋ.
ನೋ ದೇರ್ ಇಸ್ ಸೆಕ್ಷನ್ಸ್.
ಬಟ್ ಆ ರೀತಿ ಹಾಕಿಲ್ಲ ಸೆಕ್ಷನಲ್ಲಿ.
ಹಾಕಿಲ್ಲ.
ಅರ್ಲಿಯರ್ ಸೆಕ್ಷನ್ 200 ಇದಿರಲಿಲ್ಲ, ಈಗ ಇನ್ಸರ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಯಾರಿಗೆ? ಎಲ್ಲ ಅಕ್ಯೂಸ್ಡ್ಗೂ ಇಲ್ಲ. ಹಾಂ, ಎಲ್ಲಿದೆ ಆ ರೀತಿ? ಅಲ್ಲ, ಈಗ ಆ ರೀತಿ ಮಾಡಬೇಕಾಗುತ್ತೆ. ಬಟ್ ಅಗೇನ್ ದಿಟ್ ಈಸ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ದಿ ಡಿಸಿಷನ್ ಆಫ್ ದಿ ಕೋರ್ಟ್. ಬಟ್ ನಾವು ಲಾ ಈಸ್ ವೆರಿ ಕ್ಲಿಯರ್. ಬಿಫೋರ್ ಟೇಕಿಂಗ್ ಕಾಗ್ನಿಜನ್ಸ್ ಆಫ್ ಎನ್ ಅಕ್ಯೂಸ್ಡ್, ನೋ ನೀಡ್ ಟು ಹಿಯರ್ ದಿ ಅಕ್ಯೂಸ್ಡ್. ದಟ್ ಈಸ್ ದಿ ಅರ್ಲಿಯರ್ ಕೋಡ್. ಬಟ್ ಇಲ್ಲಿ ಯಾವುದು ಸೆಕ್ಷನ್ಸ್ ಏನು ಚೇಂಜ್ ಮಾಡಿಲ್ಲ. ಬಟ್ ಇಲ್ಲಿ ಸೆಕ್ಷನಲ್ಲಿ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡೋಕೆ ಈ ರೀತಿ ಮಾಡಿದ್ದಾರೆ. ಮೋಸ್ಟ್ಲಿ ಇದರಲ್ಲಿ ಈವನ್ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟಲ್ಲಿ ಪ್ರಾಬಬಲಿ ವಿತೌಟ್ ಗಿವಿಂಗ್ ಎನಿ ನೋಟ್ ಅಲ್ಲ ವಿತೌಟ್ ಗಿವಿಂಗ್ ಎನ್ ಆಪರ್ಚುನಿಟಿ ಟು ದಿ ಅಕ್ಯೂಸ್ಡ್, ಕೋರ್ಟ್ ಕೆನಾಟ್ ಟೇಕ್ ಎನಿ ಕಾಗ್ನಿಜನ್ಸ್. ಹೊಸ ಪಿ ಸಿ ಆರ್ ಮೋಸ್ಟ್ಲಿ ಮಿಸ್ಯೂಸ್ ಆಗ್ತದೆ ಅಂತ ಇರ್ಬೋದು. ಬಟ್ ಸೆಟ್ಲ್ಡ್ ಲಾಗ್ ಎಗೇನೆಸ್ಟ್ ಆಗಿದೆ ಇದು. ಹಾಂ, ಅದು ಹೈಯರ್ ಕೋರ್ಟ್ಸ್ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಮಾಡಬೇಕು. ಪ್ರೀ ಕಾಗ್ನಿಜನ್ಸೇ ಬೇರೆ ಆರ್ಡ್ರು, ಆಫ್ಟರ್ ಕಾಗ್ನಿಜನ್ಸೇ ಬೇರೆ. ಪ್ರೀ ಕಾಗ್ನಿಜನ್ಸಲ್ಲಿ ಏನು ಚಾಲೆಂಜ್ ಮಾಡೋ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. ಇದು ಪ್ರೀ ಕಾಗ್ನಿಜನ್ಸು. ಬಿಫೋರ್ ಟೇಕಿಂಗ್ ಕಾಗ್ನಿಜನ್ಸ್ an opportunity has to be given. Mostly that is in respect of private complaints is concerned. Private complaints. But government officials ಅಂತ ಏನಿಲ್ಲ ಇದರಲ್ಲಿ, ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿಲ್ಲ. ಹೂಎವರ್ ಇಟ್ ಮೇ ಬಿ, ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದರೆ ಬಿಫೋರ್ ಟೇಕಿಂಗ್ ಕಾಗ್ನಿಜನ್ಸ್ ಮಾಡಬೇಕು ಅಂತ. ದೆನ್ ವಿ ಹ್ಯಾವ್ ಟು ಸಿ ಅಗೇನ್ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಾಗ 156(3) ರೆಫರ್ ಮಾಡಿದಾಗ ಓನ್ಲಿ ಇನ್ ಕೇಸ್ ಇಫ್ ದಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಪ್ರೊಸೀಡ್ಸ್ ಟು ರೆಕಾರ್ಡ್ ದಿ ಎವಿಡೆನ್ಸ್ ಆಫ್ ವಿಟ್ನೆಸಸ್, ಬಟ್ ದೆರ್ ಆರ್ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ಸ್. What is taking of cognizance anta? There are two types of interpretation. One is, once the receipt of the private complaint, if judge proceed to record the evidence, that itself is a cognizance anta, there are judgments. Taking of cognizance is different from issuance of process. 203, 204 is different from taking of cognizance. Cognizance is not defined under the code. ಅದರಿಂದ ಕಾಗ್ನಿಜನ್ಸು ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ 156(3) ರೆಫರ್ ಮಾಡ್ತಾರೆ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದಾಗ. ದಟ್ ಈಸ್ ನಾಟ್ ಪ್ರೀಕಾಗ್ನಿಜನ್, ದಟ್ ಈಸ್ ಪ್ರೀಕಾಗ್ನಿಜನ್ಸ್ ಆರ್ಡರ್. ಇಫ್ ಜಡ್ಜ್ ಹ್ಯಾವಿಂಗ್ ರಿಸೀವ್ಡ್ ದಿ ಕಂಪ್ಲೇಂಟ್, ಇಫ್ ಈ ಪ್ರೊಸೀಡ್ ಟು ರೆಕಾರ್ಡ್ ದಿ ಸೋರನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಕಂಪ್ಲೇನೆಂಟ್ ಅಂತಂದರೆ, ದಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಈಸ್ ಟೇಕಿಂಗ್ ಆಫ್ ಕಾಗ್ನಿಜನ್ಸು. ದೇರ್ ಆರ್ ಸೆವರಲ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್. ಹಾಗಾದ್ರೆ ಇಲ್ಲಿ ಕಾಗ್ನಿಜನ್ಸ್ ತಗೊಳ್ಳೋಕ್ಕಿಂತ ಮುಂಚೆ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟಲ್ಲಿ ಈಗ ಮ್ಯಾಂಡೇಟ್ರಿ ಮಾಡಿದ್ದಾರೆ. ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟಲ್ಲಿ, ಇನ್ ಕೇಸ್ ಆಫ್ ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್.
ಸರ್, ಈಗ ಅದು 187 ಈಗ ಡಿಫಾಲ್ಟರ್ ಬೇಲ್ ಬಗ್ಗೆ ಸರ್.
187
ಡಿಫಾಲ್ಟರ್ ಬೇಲ್ ಬಗ್ಗೆ ಸರ್. ಯಾಕಂದ್ರೆ ಈಗ PC ಕಸ್ಟಡಿ ತೊಗೊತಿದ್ರು ಸರ್, ಪೊಲೀಸ್ ಕಸ್ಟಡಿ.
ಹಾಂ,
ಫಸ್ಟ್ 14 days ಇತ್ತು ಸರ್.
ಹೌದು.
ಈಗ ಎಷ್ಟು ಮಾಡ್ಯಾರ?
ಅದು ಪೀರಿಯಡ್ ಎಲ್ಲ ಜಾಸ್ತಿ ಮಾಡಿದಾರಲ್ಲ, 60 days, 90 days.
ಹಾಂ ಸರ್,
60 days ಅದೆಲ್ಲ ಹೋಯ್ತು. ಈಗ ಜಾಸ್ತಿ ದಿವಸ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೋಸ್ಕರಲೇ ಅವರು ಈಗ ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಒನ್ ಆಫ್ ದಿ ಗ್ರಿವಿಯನ್ಸ್. ಇದರಲ್ಲಿ ಇದೆ ನೋಡಿ, CRPCಲಿ ಮಾಡಿದ್ದಾರೆ 60 days, 90 days ಆ ರೀತಿ ಮಾಡಿದ್ದಾರೆ. ಪೀರಿಯಡ್ ವಾಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಮಾಡಿದ್ದಾರೆ. ಈವನ್ ಬರೀ ನಾನು ಇಷ್ಟು ಹೇಳಿದೆ ಅಷ್ಟೇ. ಬಟ್ ಈವನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಲ್ಸೋ, ಜಡ್ಜಸ್ಗೂ ಕೂಡ 1 ತಿಂಗಳೊಳಗೆ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಬೇಕು. 1 ತಿಂಗಳೊಳಗೆ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಲಿಲ್ಲ ಅಂದರೆ ಮತ್ತು ಅನದರ್ 15 days ಟೈಮ್ ಇದೆ. ಆ 15 days ಟೈಮಿಗೆ ಹಿ ಹ್ಯಾಸ್ ಟು ರೈಟ್ ದಿ ರೀಸನ್ಸ್ ವೈ ಹಿ ಹ್ಯಾಸ್ ಟೇಕನ್ 15 days ಟೈಮ್ ಅಂತ. ದಟ್ ಈಸ್ ಆಲ್ಸೋ ದೇರ್, ಸಮ್ ಚೇಂಜಸ್ ಆರ್ ದೇರ್, ಬಟ್ ಇಟ್ ರಿಕ್ವೈರ್ಸ್ ಎಲಾಬರೇಟ್ ಡಿಸ್ಕಷನ್ ಆಲ್ಸೋ. ಜಡ್ಜಸ್ಗೂ ಕೂಡ ಆ ಥರ ಮಾಡಿದ್ದಾರೆ. ನಾನು ನೋಟ್ಸಲ್ಲೆಲ್ಲ ರೆಡಿ ಮಾಡಿದ್ದೀನಿ, ಬಟ್ ಟೈಮ್ ಇಲ್ಲ, ಶಾರ್ಟ್ ಪೀರಿಯಡ್. ಇನ್ನೊಂದು ಸರಿ ಯಾವ್ದಾದ್ರು ಇಲ್ಲಿ ಧಾರವಾಡ ಸೆಟ್ಟಿಂಗ್ ಇದೆ, ಕರೀರಿ, ಡೀಟೇಲಾಗಿ ಮಾಡೋಣಂತೆ. ಹಾಂ, ಹೇಳಿ. ಬಿಫೋರ್ ಬ್ರಿಂಗಿಂಗ್ ದಿ ಎನಾಕ್ಟ್ಮೆಂಟ್, ದೇ ಶುಡ್ ಹ್ಯಾವ್ ಥಾಟ್ ಆಫ್ ದಿಸ್. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, FSL ರಿಪೋರ್ಟು, ನೀವು ಟ್ರಯಲ್ ಇದೆ, ಒಂದು ಟ್ರಯಲ್ಗೆ ಒಂದು ಸೆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ, ನಾನು ಅದನ್ನ ಹೇಳಲಿಲ್ಲ. ಈವನ್ ಕಾಗ್ನಿಸಬಲ್ ಅಫೆನ್ಸಲ್ಲಿ ಟ್ರಯಲ್ ಕಮೆನ್ಸ್ ಆದರೆ 60 days ಒಳಗೆ ಕಂಪ್ಲೀಟ್ ಮಾಡಲಿಲ್ಲ ಟ್ರಯಲ್ ಅಂದರೆ ಹಿ ಶುಡ್ ಬಿ ರಿಲೀಸ್ಡ್ ಅಂತೊಂದು ಪ್ರಾವಿಜೋ ಮಾಡಿದ್ದಾರೆ. ದೆರ್ ಈಸ್ ಎ ಪ್ರಾವಿಜೋ, ಆ ರೀತಿ ಇದೆ. ಬಟ್ ಏನಂದರೆ ಈಗ ನೀವು 2 ವರ್ಷ 3 ವರ್ಷ FSL ರಿಪೋರ್ಟೇ ಬರಲ್ಲ. ನೀವು ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಫಸ್ಟ್ ಮಾಡಬೇಕು. ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಕೊಡ್ದಲ್ಲೇ ಕಾನೂನು ತಂದರೆ ಏನು ಉಪಯೋಗ? ದೀಸ್ ಆರ್ ದಿ ಡ್ರಾಬ್ಯಾಕ್ಸ್ ಇದೆ, ಇಲ್ಲ ಅಂತಲ್ಲ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. ಬಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಥಿಂಕ್ ಇಟ್ ಇನ್ ಅದರ್ ವೇ ಫಾರ್ ದಿ ಪರ್ಪಸ್ ಆಫ್ ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್, ಫಾಸ್ಟ್ ಡಿಸ್ಪೋಸಲ್. ಅಗೈನ್ ವಿ ಹ್ಯಾವ್ ಟು ಎಕ್ಯೂಪ್ ವಿತ್ ಆಲ್. ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಕೊಡಬೇಕು, ಟೈಮ್ ಸ್ಟಿಪ್ಯುಲೇಷನ್ ಮಾಡಬೇಕು, FSL ಅಲ್ಲಿ ನೀವು ಇಷ್ಟು ದಿವಸದೊಳಗೆ ಕೊಡಬೇಕು ಅಂತ ಮಾಡಬೇಕು. ಈಗ FSL ನಿಮ್ಗಿರೋದೇ ಸೆಂಟರ್ಸ್ಗಳಿರೋದೇ ಕಡಿಮೆ. ಎಲ್ಲನೂ ತೊಗೊಂಡೋಗ್ಬಿಟ್ಟು ನೀವು 6 ತಿಂಗಳೊಳಗೆ ಕೊಡಿ, 3 ತಿಂಗಳೊಳಗೆ ಕೊಡಿ ಅಂದರೆ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಇಲ್ಲದೆ ಅವ್ರೇನು ಮಾಡ್ತಾರೆ? ಕೆಲವು ಕಡೆ FSL ಆಫೀಸರ್ಸೇ ಇರಲ್ಲ. ದೇ ಶುಡ್ ಹ್ಯಾವ್ ಥಾಟ್ ಆಫ್ ದಿಸ್.